Good afternoon.
May it please the court, Olivia Arbino for plaintiff appellants Teresa and Randy Locke. I would like to reserve 5 minutes for rebuttal, please.
5 minutes, very well.
At issue in this appeal is the discoverability of surveillance videos in personal injury cases. Plaintiffs serve defendants with interrogatories and requests for production for all surveillance materials in defendant's custody or control. Defendants objected to these discovery requests, claiming that those materials would be protected under the work product doctrine. The trial court rejected this argument and granted plaintiffs' motion to compel these materials. Defendants then filed a motion to alter or amend the trial court's order to require only the production of the surveillance materials that defendants plan to use at trial. The trial court agreed and modified its order, thereby narrowing the scope of the materials that defendants had to produce to—
There's not a live issue here, though, that this is work product, right? I mean, everybody concedes it's work product, or is that a live issue? Is that something we still have to work on, is whether or not these surveillance, I mean, they strike me as being work product.
Whether or not it's work product is not what's up for appeal. It is our position that any such work product privilege has been waived. Firstly, due to the fact that they have never provided us a full privilege log of all their surveillance materials, and because they decided to use these surveillance videos as testimony in trial. The fact that they have decided to use some of the videos creates a substantial need for plaintiffs to see all the videos.
So that makes it sound like it is work product, and we don't have to really worry about that step of the analysis. We're going straight to substantial need.
We do not feel the need to rehash whether or not the surveillance videos were created in anticipation of litigation. No. The ruling of the trial court, which allows defendants to avoid their obligations to produce otherwise discoverable material merely by declaring that they don't want to use it at trial, is an unprecedented legal carve-out, both by Tennessee law, which has uniformly held surveillance materials should be produced and are discoverable, and also by case law in other jurisdictions, including the case law that the trial court themselves relies on in their opinion, granting the motion to alter or amend. In that case, West v. Lake State, the court ruled that these videos had their privilege waived because they did not properly produce a privilege log, but the court also analyzes the substantial need question for the sake of thoroughness, and they do rule that this evidence, even though defendants only plan to use those surveillance materials for impeachment, was substantive evidence and was discoverable, and that there was substantial need by the plaintiffs to see this surveillance material. Defendants have pointed to a specific quote in their briefing from West v. Lake State, which they argue creates a limited scope of this substantial need. Respectfully, this is a misreading of the case. West v. Lake State, throughout the opinion, discusses how, for the sake of fairness, all the videos must be produced for plaintiffs. And West v. Lake State does not address the exact situation we have here of defendants planning to use only part of their surveillance materials and not all of them. Therefore, this quote discussing that there is a substantial need when the videos are contrary to the plaintiff's argument is not limiting the scope of substantial need, but more discussing a threshold. So again, here there are videos that defendants plan to use at trial, and there are videos that they do not plan to use. Presumably the ones they plan to use at trial are contrary to plaintiff's argument and support defendant's argument. That is enough to get all of these videos into the realm of substantial need.
Well, that was going to be my question. How far does this go? Once a defendant says, well, we want to use a portion of the video, does that mean all their surveillance necessarily has to come in, or do you have to do a separate analysis about substantial need over the entire time frame?
It is our position that they all become discoverable for the sake of fairness and completeness. In personal injury cases, the issue is Miss Locke's nerve injury from a negligent surgery performed by defendants. We're not claiming that she can never walk again. So if there's a video of her walking from her home to her car without issue, that is not going to show the complete picture if there is also another video of her hobbling to her car and in pain.
Well, I guess what I'm wondering here is in terms of approach, wouldn't the better approach be here to say, okay, you've shown a substantial need certainly for what is going to be shown at trial. But then plaintiff looks at it and then would need to make an additional showing of substantial need to why additional surveillance video is necessary.
So in West v. Lake State and also in the case law cited from Tennessee, these cases all explore that videos can be misleading when they are all not shown or the complete video is not shown and that the complete picture is not shown.
Yeah, but that would be, you would have some sort of temporal limits on that, like the example that you give in the brief about 30 seconds of a walk from a car to a building and then omitting the next 30 seconds. That has a temporal time zone there that you're looking at. That makes a little more sense than, well, you get that video plus one from 4 months ago.
Yes, so again, it is our position that the complete picture of whether or not Mrs. Locke has received a permanent injury, that is permanent, right, is a word that involves a long period of time. So if there is a video that shows 1 month her okay due to whatever circumstances allowed her to lead a relatively normal life that day, but there is another video from 4 months later when circumstances of life again, maybe she did not take as much pain medication, maybe it's raining and so it hurts more, that is still part of the complete picture that plaintiffs have a substantial need to see and have the ability to show the jury to demonstrate the total picture and the total circumstances surrounding Mrs. Locke's injury.
And so would it work, would the principle work both ways then? Let's say a plaintiff wants to do one of these day of the life in the plaintiff's videos, and there's a lot of outtakes from that as a way of showing damages as a result of an injury. Would defense then get to see all the video from that as well?
By that logic, yes, most likely. And again, personal injury, an injury is not going to act the same it does every single moment of the day. So presumably both parties and their lawyers acting in the best interest of their clients are going to want to show the footage that best demonstrates their argument, but that's not the complete picture, and that's not picking and choosing relevant evidence and picking and choosing what relevant evidence only the parties wish to show is not in the spirit of fairness in the law. Additionally, there is a Tennessee state court case from this court, Pettis v. Hurst, which is a car accident case that explores and directly dismisses defendants' arguments in this case. In that case,
does that case deal with work product at all?
Yes, they do claim privilege. I do not believe.
I mean, but the case doesn't analyze how the privilege applies in that case. They just say, oh, Rule 26, this is discoverable, this goes outside the rule, but it doesn't seem to have any analysis of what the substantial need was in that case.
It does not. You are correct that it explores.
And it seems odd because that's a 93 case, and I think Tennessee adopted the Fed version in '79, so I'm just wondering where the analysis is.
So the substantial need language was in the Tennessee Rules of Civil Procedure when Pettis v. Hearst came out. And while that phrase or that analysis, the analysis we see later in Boyd, is not necessarily as explored in Pettis v. Hearst, the court very distinctly does say that the request for the surveillance materials were entirely consistent with the Tennessee Rules of Civil Procedure 26. So it would encompass the reasonings in and the obligations and the tests in the Tennessee Rules of Civil Procedure 26 and ruled that the surveillance videos should still be produced.
All right, thank you. We'll hear from you on rebuttal. Good afternoon.
Good afternoon, Your Honor. May it please the court, my name is Briggs Dixon, here on behalf of the appellee defendants. And I want to address just a few points raised by the appellant's counsel. First, this is an issue on the discoverability of work product.
So
Whether,
as far as you're concerned, work product's a resolved issue. This is what we have here.
yes, Your Honor, and I tend to agree with your assessment that this is classic work product, and I believe the trial court even said in its order.
Well, it is factual work product.
Correct. Yes, there is a distinction. It's factual work product, not opinion work product. We're not claiming.
So it's a little less worrisome when you don't have opinions thrown in. It's just pictures.
Well, I wouldn't necessarily categorize it as worrisome, but there are different standards for each
Right.
prong of work product. What I wanted to address just briefly from the appellant's argument is that they stated, I tried to write this down the best I could, that the trial court rejected that this was work product. That's incorrect. The trial court specifically found it was work product under 26.023, and they engaged in the proper step-by-step analysis to say, is it work product? Does the plaintiff demonstrate a substantial need? And they went through that analysis. So they did not reject this being a work product. Indeed, the trial court said, this is classic work product. Surveillance can't be or wasn't produced for any reason but in anticipation of litigation. There were some statements made at the very beginning of the appellant's argument on waiver of work product privilege. That's, number one, it's not an issue before this court. And number two, I'd submit that that's completely false. It's never happened. We've consistently asserted work product privilege, and that's why we're here. Number two is that there was an assertion that we did not produce a complete privilege log. That's also false. I don't know where that is in the record. I know it's not in the record because we have provided a complete privilege log. We went further and we provided everything in our privilege log. But with that being said, I want to direct the court to a principle, or really not a principle, but the legal foundation of why we're here today that's not been mentioned at all in the argument, in the principal brief of the appellant, the reply brief of the appellant, or here today. And that is that your honors are deciding this case on an abuse of discretion standard. Now, the standard that applies is exactly what the trial court followed. Or, excuse me, the rules that apply are exactly what the trial court followed. That's the rule set forth in Tennessee Rule of Civil Procedure 26023, the standard for discoverability of work product, and that's further explained in Boyd v. Comdata in a well-written opinion by former Justice Koch. So, getting back on track.
The same judge that wrote Pettis, who didn't even mention work
Exactly,
product.
and let me address Pettis while we're on the topic. They've argued that we waived work product. Work product must be asserted. There's no indication it was asserted in Pettis. There's no analysis. But there is analysis in Boyd v. Comdata, and we have asserted work product from the start on this. So it is an issue that your honors can look at through the lens of what's discoverable under work product.
What about the principle here that, with a little creative editing, what looks like a video that shows an injured plaintiff can show a plaintiff that maybe doesn't have a severe injury at all, and why shouldn't the plaintiff be able to examine what the video, at least temporally close in time, came before and after what's being showed in court?
Well, I would submit to your honors that, number one, we've produced what we have. The video shows what it shows. The insinuation that there's been editing, All that is not in the record. That's not been the subject of anything before this court other than speculation. It's pure fantasy. But I will say this in response to your Honor's question.
Maybe editing is a little too harsh a term here, but perhaps that the video started in an inopportune place for the plaintiff's case, and if it had only shown 10 seconds beforehand, it could show the hypothetical grimace that either preceded or followed whatever act the video shows.
Sure. So to answer your question, it will always be the case that there could be more video. It will always be the case, whether it's video that's good for us or whether it's video that's not good for our clients. There's even, if you look on certain best practices of surveillance, they say try and get surveillance on both days so that you can show consistency in what the subject's showing. So
if there can always be, if there's more video, why doesn't it just come out? Why not just let it come out?
Well, the reason is because that's not what the standard is for discovering work product. This is the fruits of the defendant's labor.
Well, the standard is substantial need, right?
Yes, the standard is substantial need.
Can this plaintiff go back and get video of everything she's been doing? Has done over the past few months?
Well, it's interesting you bring that up.
The answer is no.
Of course.
So if you have it and you you're willing to say you can have what we're going to use to impeach you with, well, that tells you what that video's going to be. But to say you can't have what we're not going to impeach you with, which we took at the same times, or even in the same time frame. I'm not as concerned about months as maybe some others are. But why isn't that discoverable?
Well, the issue all comes back.
Why isn't it? Why don't they have a substantial need to show that maybe they want to show it gets better, it gets worse, it gets better, it gets worse?
Number one, the plaintiffs will always have, and I said that there's always going to be an opportunity for more video, but the plaintiffs always have their own testimony. It's the plaintiff being defended.
Absolutely they do.
They can testify
Absolutely
to
they
whatever
do.
video does not show. They also have medical records which can provide objective and subjective proof.
Absolutely
it's not the
they do.
defendant's burden to provide the proof to support the plaintiff's position. Now, I want to.
But it's your burden if you have information for it to be discoverable as a general rule.
As a general rule, and that's the guise under which the appellants argue that this is discoverable. But we're not operating under the general rule. We're operating under the specific rule codified on Tennessee Rule of Civil Procedure.
I know what we're operating under. Now tell me why it shouldn't come out.
It should not come out because the substantial need is geared toward only the evidence that will be used at trial. I give your honors a...
well, that's kind of in the eye of the beholder, isn't it?
Excuse me, I'm not understanding.
Well, you don't think there's a substantial need for them to see it because you're not going to use it. But they might think there's a substantial need because they might want to use it.
Well, the question becomes why, or again, it's work product. I believe what
it is, but it's factual work product.
It's factual work product, but that doesn't lessen the burden of showing a substantial need.
That's right.
The substantial need for corroborating evidence. And I'll point to the cases that they've cited, Pettis being the seminal case, and also Cockrell and Seagraves, which rely heavily on Pettis. All those cases dealt with impeachment evidence, for one, that the defendants in those cases didn't produce to the plaintiff until upwards of a week at trial. What the rationale was behind those items being excluded, not under work product, it was an ambush. It was trial by ambush. So if we're talking about, Your Honor, Judge Bennett, about substantial need, they would love if we ambushed them at trial with corroborating evidence. So there's no policy rationale that defendants should have to disclose all of the evidence that they'd never intend to offer at trial. And I'd show a corollary with consulting experts, also under Rule 26. Consulting experts are not required to be disclosed unless you're offering them at trial. Just like surveillance footage, consulting experts may have opinions that are very damning for a defendant's case, and that's why they're not disclosed. That happens on both sides. But that should inform this court's analysis on how to treat a substantial need. And there's a similar, but not yet exactly the same, standard for getting consulting experts information or things that are within the purview of a consulting expert. So we would submit that the plaintiff doesn't have a substantial need for any corroborating evidence from a video that's in harmony with their claims. Now, is there anything created by an adversary's counsel that must always be produced when asked? Because that's the standard advocated for by plaintiff appellants. They say anytime you get surveillance footage, you must produce all of it if we ask. That ignores the standard set forth in 26023. It ignores Boyd v. Comdata. It's a blanket approach, an all or nothing approach. And I hearken back to Your Honor McBrayer's analysis. If this is the standard that defendants must always produce their work product, surveillance, no matter when it's asked for, and they must produce the entire catalog of their files, that opens the plaintiffs up to the exact same requests. We can obtain the most sensitive videos. There might as well be a forensic investigation of every cell phone in the plaintiff's possession whenever they file a claim. Because if the defendants have to produce evidence that corroborates their claim, why shouldn't we be able to open their files and see if they have evidence that hurts their claim?
Okay.
It has to go both ways.
What's wrong with that? Ask for all their video.
I would submit that they would object to that. I think that would make litigation unwieldy, and I think it's inconsistent with the whole standard of work product and what's relevant in discovery. So
I guess what's bothering me is you get to decide what's relevant here.
Well, defendants always get to decide what evidence they put on a trial.
Well,
they can always
agree.
decide what medical records they want to put forward.
But
maybe some are better than
there's
others.
some other relevant things to this litigation that you've got pictures of, but you just don't want to show it.
And as Your Honor McBrayer mentioned, they can do a day-in-the-life video. They have testimony of the plaintiff, the subject of the video. They can testify, well, if we have a video of a plaintiff who claims a severe debilitating nerve injury, and she's walking out of the steps of the YMCA after exercising, then they can say, well, that was a good day for me. And you didn't get the video of me the months or the days after where I was just really struggling. That's testimony that can be offered just the same to rebut that video. We have the video shows what it shows. Importantly, I think it's important to note, the plaintiffs have not offered any authority to show defendants must always produce all of their surveillance. And the reason I say that, and the reason it's important, is because, again, we're on an abuse of discretion standard on this appeal. That means the court doesn't substitute its judgment for the trial court. What the trial court did was completely appropriate. And again, Your Honors, the appellants have not demonstrated any basis to find an abuse of discretion. The trial court relied on West. Now, there's been some discussion.
Isn't one of the standards when you look at abuse of discretion, isn't one of them following the law?
Yes.
Well, so if the law is that you should give up all your video, then there has been abuse of discretion, hasn't it?
Well, that's not the law, but if that were the law, then certainly.
If that were the law, then that's an abuse of discretion. Then that's what we're here to figure out.
If the law said, which it doesn't, but if the law said anytime a plaintiff asks a defendant for surveillance materials, they must produce them, and that law wasn't followed, then sure, that would be an abuse of discretion. But I submit to Your Honor, that's not the case here.
I understand. That's why we're here,
Yes,
to
sir.
figure the answer to that question out.
Yes, Your Honor. A few closing remarks as I'm almost out of time, but I want to leave the court with a few points to consider. There is a statutory privilege codified at Tennessee Code Annotated 24-1209. I'm sure Your Honors are familiar with it. It states communications between an attorney and a private detective or investigator hired by such attorney while acting in their respective professional capacities will be privileged, shall be privileged. So the standard advocated by appellants today would mean that even those protected private investigator communications are subject to discovery, contrary to statutory privilege. So if there's an abuse of discretion, it would have actually been holding as the plaintiffs wanted in this case, that all surveillance materials are subject to discovery. I'd also note that timing is an important
I
consideration.
thought we were just talking about videos.
Well, the scope of their order is all surveillance materials. When we included in our privilege log a surveillance report,
So
they've not limited that request to anything. It's all surveillance materials. And I just note,
the issue presented is discovery of surveillance videos.
sure, and I'm only arguing the logical consequences of the position advocated for by the appellants.
Okay.
That's what the point of that. But I want to also note that timing is an important consideration as well. Under the plaintiff's appellant's rule, if it were so adopted, they would be permitted to file a complaint, immediately request all discovery. Defendants, as you in healthcare liability, we have a pre-suit notice period where perhaps surveillance is done. The defendants would never get the benefit of that surveillance material. Why even do the surveillance? It would effectively negate the purpose of surveillance entirely. So, as I'm out of time, I just want to conclude there was no abuse of discretion. I submit that Your Honors will not find any argument for an abuse of discretion in the plaintiff's briefing, and I believe that the court's order shows that it followed a reasoned, step-by-step, appropriate analysis based on applicable precedent in Boyd v. Comdata, Tennessee Rule of Civil Procedure 26023, and persuasive authority in West to reach the right conclusion in this case. If you have any other questions, I'm happy to answer, but I'm out of time.
Thank you, Mr. Dixon.
Thank you.
All right. Rebuttal? How broad are you seeking to discover what the defendants have?
It is our understanding that they have surveillance videos, and those are what we would like to see. We have not been notified of other surveillance materials in existence. Again,
Well, what about in notes between an investigator or the videographer and the defendant's representatives?
presumably notes would fall more, or notes, writings, communications would fall more under opinion work product as opposed to fact work product, which we've not necessarily explored in this case, nor is that issue in this case.
So the breadth of what you're seeking is literally videography?
Yes, Your Honor.
Okay.
So in regards to defendant's argument that somehow overturning the unprecedented legal carve-out that the trial court created would result in a wildly burdensome discovery for personal injury cases, the seminal moment in our analysis today is not that surveillance materials were taken, it is that the moment defendants planned to use those materials at trial. Had they taken surveillance videos and never planned to use them at trial, asserted work product privilege properly, and those would never, quote unquote, see the light of day outside of the lawyer's offices, we are not contesting that that would be a different analysis where perhaps privilege would apply. That, however, is not the situation here. They are attempting to use the work product privilege to both create a shield and a sword for them, that they can take some surveillance videos, pick and choose the ones that they would like to use as a sword, and keep the rest behind the shield of work product privilege, which is universally rejected as a way to use the work product privilege and to use privilege otherwise.
Now, you say that's universally rejected by...
Not only is it rejected specifically in the surveillance videos realm in the cases that we have cited, including in West, but the use of privilege as a sword and a shield is a concept that is known to be.
Well, I mean, I guess you make it sound like it's such a clear-cut issue, but if you look at, first of all, West, the whole analysis of this issue is dicta, right? Because the court had already determined that the privilege had been waived, and then said, well, out of an abundance of caution, I'm going to address this issue. And then West relies on, what is it, Fisher? Fisher talks about a split, or how the authorities are changing over over time. So it's not, I don't think it's fair to say it's universally accepted that this all comes in, is it?
Your Honor, that is fair. I am not familiar with every jurisdiction's case law on this matter. However, other case law we have cited and cite themselves to cases in other jurisdictions that say these materials are discoverable. I believe we cite an Eastern District of Virginia case, Gutshell, and in that it says, the court says, we will follow the majority of other jurisdictions and rule that these videos are all discoverable.
Turn into this particular instance, why wouldn't it be appropriate for a court to say, you know what, you've shown relevance here because clearly the defendants have said this is the segment of the video that they're going to introduce at trial, so it's relevant, and we've got a substantial need here because of the nature of video, that it captures a moment of time that the plaintiff no longer can recapture. But then to go back and say, well, I'm not going to give you any more until you tell me why you have a substantial need for additional video. I mean, why isn't that inappropriate? Why isn't what the trial judge here, wasn't that a completely appropriate way to handle the situation?
So it is hard when we do not have a complete privilege log, which is an issue in the record that has been briefed in our briefs to the trial court.
I've seen a privilege log, and you're saying it's not complete. How do you know that?
By the fact that we are here, we can put together the fact that it must be incomplete. The videos on the privilege log are the ones that they plan to
I don't
present.
follow that because you're here, the privilege log must be incomplete. That doesn't make any sense to me.
The privilege log, the videos on their privilege log are the videos that they say they plan to use for impeachment at trial. They asked the trial court to amend its order to only require them to produce the videos that they plan to use for impeachment at trial. If there are not other videos, there would be no reason for them to ask the trial court to make that distinction. Otherwise, they would have just been asking for an improper advisory
So you're saying that there
opinion.
needed to be more specificity here. In other words, there has to be a universe of other video segments that weren't identified in the privilege log.
Yes, Your Honor, and so it's hard for me to answer your question when we don't know what we are missing.
What's the universe? Okay.
And I'm out of time, so unless you have further questions, thank you.
All right, thank you both for your arguments. We'll take this very interesting case under advisement. Thank you.